master checklist anthem. The master checklist anthem. Identify the problems, state the facts and quote the text. Start with the literal rule, what does the dictionary suggest? As held in the Sussex peerage case, this is the primary tool. Right, according to the plain and ordinary meaning of the words as a rule. But if that leads to absurdity, like in Moore Estates, LTTV Dawson warned, you shift to the golden rule where the literal meaning is reformed. Use gray v. Pearson to avoid repugnancy of absurd intent and right. However, the literal meaning leads to an absurdity, does not resolve the ambiguity. Therefore, the court must ascertain Parliament's intention using the mischief rule. Apply Hayden's case and ask the question for common law before the defect, the remedy, the true reason to respond. When words are grouped, no seek to associate is what you choose. Right, the word takes its color from the surrounding words. If a list is followed by general words, adjust them generous, keeps them in their class. Expressio, uni, assessed, exclusio, alterius. One thing others cannot pass. When general rules meet specific ones, the specific takes the crown. Generalibus, specially a derogant, strikes the general provision down. For context, check the long title or preamble to see what the act meant, as shown in black clause and international LTDV papier work. And marginal notes help context, says R.V. Montilla. But plain words they can prevent. Even though statute is unclear, how did they view it long ago? Campbell College v. Commissioner evaluation applies contemporanea expositio. And if the act is still ambiguous, look to parliamentary debate. Pepper B. Hart says Hansard can set the record straight. Now for the presumptions, reaffirmity sets the stage. Parliament is presumed not to intend to impair vested rights without clear language on the page. For crimes, talk and tongues be priest that is strictly used. Where a penal provision is ambiguous, the benefit of the doubt must be given to the accused. To alter the common law, each VR says you need words clear and direct for natural justice and the right to be heard. Smith v. L.J. Williams LTD. You must respect to conform with international law and treaties. Salomon v. C&E Commissioners is the guide. And for the presumption of constitutionality, the challenger carries the burden to decide. Just cite AGV Morgan, Hines v. R. or Faustin v. AG of P&T with pride. When dealing with the Constitution, Ministry of Home Affairs v. Fisher is the key. Constitutional provisions protecting fundamental rights must be given a generous and purposive interpretation. Absolutely. If rights are limited, the proportionality test applies. Check AGV Achille Charles, UKPC 31 to see where the balance lies. And for pre-independence laws, saved by the savings law clause, St. Matthew v. State, UKPC 33 and Derby's VR CCJ 19 to interpret the flaws. You've analyzed the law, the presumptions and the facts, address the counter arguments and formalize your acts. Give a clear recommendation, don't leave them in suspense, and close your legal opinion with this final sentence. In light of the foregoing, the preferable interpretation is, and state your defense.